Hi, everybody. Welcome to the Community Foundation's final webinar of 2021. This is going to be a 45-minute webinar on legacy and estate planning, and we're really excited to bring our guest speaker to you today, Curtis Kaiser. It is being recorded, so you can look at this presentation at a later time as well and take more notes. We'll answer questions. We'll do some polls and answer questions throughout the webinar, but we will save some time at the end. So please go ahead in the chat and put some questions in there, and just be sensitive to any questions that might start with I, me, or mine, because that's something you may want to see Curtis for individually, but maybe something that is in general in scope. And if we can't answer your question here, please, we'll have our information. We'd love to hear from you. And the webinar will be emailed to everybody who registered. So we'll go ahead and get started. A little bit about the Community Foundation. If you don't already know who we are, we'll go through that. Some of the challenges with traditional estate planning, what a successful estate plan looks like, and maybe some pieces that you might have overlooked. And of course, the charity piece at the end, and specific tools and resources on how we can help you get there. We're going to start with a poll because we want to know who's in the room. The Community Foundation serves a lot of different people and organizations and entities, and we want to know who you are. So maybe you're here ready to set up a trust. Maybe you're updating your trust. You're interested in adding charitable giving to your trust, or you're a professional advisor who is really maybe looking for some other tips and tools that you can give to your clients. It looks like the overwhelming majority of people are pretty savvy, have joined us today. You're either a professional advisor and you want to advise your clients on this subject matter, or you're updating your trust. So Curtis, we've got some pros in the room. This is wonderful. Thanks for taking the time to do that. Okay, so our mission is to initiate positive change for Long Beach, primarily through giving, stewardship, and strategic grant making. We're 25 years old this year, and we're one of over 850 community foundations nationwide. And we're really administrators. People ask us all the time, well, what do you do? Well, we say we administer charitable accounts. That's probably the best way of describing it. And a little misconception on us, grants or money that goes out from clients or from you as an individual can go anywhere in the United States. We focus locally and our resources locally and our partnerships locally, but we have clients all over the US, and money goes out all over the US as well. And who we work with, you see the list here. It's pretty vast. If you're an individual, you might be one of these particular types of folks that have different situations, and you are leaving charity in your trust for a specific reason. And this is my wonderful opportunity to introduce Curtis Kaiser. And many of you might already know who he is, but if you don't already, he has over 21 years in the industry. He really specializes in sustaining legacies and wealth across generations. And majority of his clients are in California, but now with the internet and Zoom and all of that, I'm sure he's expanded that. But he's really client-centric. I know him personally from the Estate Planning Estate Planning and Trust Council of Long Beach, and he's just a really great individual and a wonderful estate planning attorney that we enjoy working with. Something you may not know about Curtis is that little tidbit of information. He has officiated 11 weddings. So if you have clients that need someone to marry them, it is part of some of the process here, then maybe you want to give him a call for that. So without further ado, Curtis, we're happy you're joining us today. You have the floor.
Thanks, Marcelle. And yeah, Marcelle asked when I told her that, she said, were they internet weddings? And I said, no, they were all done before COVID. Probably doing an internet wedding wouldn't be that fun, but hopefully an internet webinar about estate planning and charitable planning, hopefully will be good. You're at home, maybe you're still in your sweatpants, and you can learn a little bit along with Marcelle and I today. So let's see if I can start the presentation. Yes, I can. All right. So rather than talk to you about things that many of you may already know based on Marcelle's running of the poll, that there's some professional advisors with us, there's some people who have an existing estate plan and might want to refresh it. I'll give you my perspective on our approach, how we do it at our firm, and how what we do differs from what I'll call traditional estate planning. So traditional estate planning, the idea is that you've been told many times by a professional advisor, a trusted friend, that sort of thing, you need to get an estate plan in place, okay? Perhaps you've been hearing it for a while. You need to get an estate plan in place. You have a kid, or you have a house, or you're an adult now. You need to get an estate plan in place. And if you look at the little magician there with his hat, it's circled the phrase living trust. And perhaps you've heard, in California here, we need to have a living trust, not a will, because a living trust will help avoid probate. So I've been told I need a living trust. I've been told I need an estate plan. I heard I need a living trust. So I'm going to go to an estate planning attorney that is going to sprinkle some magic dust, cast a magic spell on these documents so that everything will work the way it's supposed to work. And this magic document mentality is so pervasive in our industry that it even really extends to the profession, in the sense that in the software that I use to draft our estate plans, there's a provision that's actually called the magic wand provision. And what does this magic wand provision purport to do? It says that, hey, the client intends to put all of their assets, except for certain assets like retirement accounts, life insurance proceeds, annuities, the bulk of their assets, that they intend to put them in their trust. So if they accidentally didn't, this magic wand provision should make everything okay. And everybody's working towards the same goal here, which is that the creators of the plan want everything to be nice and easy, and they want everything to be nice and easy for their loved ones when the creators pass away someday. They want it to be nice and easy. If I ask my clients, what are we looking to accomplish? They just want something nice and easy, want to take care of our loved ones, don't want to have to go to court, anything like that. The problem is that everyone's looking for something nice and easy. And when the chips are down or the musical chairs stop and the plan actually has to be carried out, the loved ones who come into an estate planning attorney's office to see them are under the impression that it is going to be nice and easy, that they're going to walk into the office of my colleague John Albin on the call, or someone like myself, and say, okay, where do we push the easy button and receive the money? And I'll take a look at the plan, whether it was drafted by my firm 10 years ago or another firm 5 years ago or 15 years ago, and realize within 10 minutes, this is not going to be an easy situation. It's starting to look more like this. Well, how is that possible if a good attorney sprinkled their magic dust on the documents X number of years ago? Why are we experiencing these type of problems, and what type of problems are they? Well, it's typically assets are not aligned or titled in the name of the trust. Beneficiary designations aren't right. There's confusion or misunderstanding between the beneficiaries or the trustee, that the family thought of it as kind of a static document that was taken care of back when they went and saw the attorney 11 years ago. And everyone in the midst of their grief is getting a cold dose of reality when we're having to share this with the clients. Oops, Marcelle, there we go. Okay, I'm going to take it back. And okay, let's see.
So Sorry about that. My computer is taking over your screen for some
Okay.
weird technological reasons. So
Okay. I'll see if I can take it back.
Go ahead and try again.
Okay, perfect. There we go. There we go. Okay. Have any of you heard the expression, the cobbler's kids wear no shoes? It's probably about 2/3 of my clients have heard of it. It's the idea that that the cobbler is so busy making shoes for all his customers that the kids don't have time for shoes. And I have to confess that this was a little bit of what I experienced 2 years ago when I was getting ready for a significant surgery. I received a kidney transplant from a really nice neighbor, and she's doing well and I'm doing well. But leading up to the surgery, my wife was saying, hey, I don't really have a good handle, Curtis, or a good understanding on how the plan would work. If something happens, can we go over things? And so we did. I set that up. And I also asked my team to kind of do a dry run of the plan to make sure that everything that the plan was supposed to achieve was actually in place if something had happened. And they came back to me, they came back and said, actually, Curtis, there are 3 of your assets are not properly aligned with the plan, are not titled to the trust. And I said, what are you talking about, to my team? I had had another attorney do my estate plan just to kind of have another set of eyes on it. And I don't know if you've heard the expression, a lawyer who represents himself as a fool for a client, but that's kind of the ethos I was adopting, I was operating under. So my attorney, Rebecca, I said, hey, Rebecca, how come these assets aren't aligned with my trust? And she said, well, Curtis, didn't you read behind tab 5 of your binder, the 20 pages of instructions on retitling the assets I gave you? And I said, no. And here's my magic document mentality. I had paid her good money. I had spent good time with her. I trust her. I liked her. I just figured everything was taken care of. And I was so glad to be done that maybe she said something about reading tab 5 and I didn't really focus in on it. And that's what we had experienced with a lot of our clients. So talking about having the assets aligned, here's a visual of an unfunded trust. Think of it as, ideally, we want everything to go into the treasure chest, into the name of the trust like this. But if we have an unfunded trust, what that would mean is, let's say it's the Marcelle Epley Trust. But instead of Marcelle's assets all being titled in the name of Marcelle, trustee of the Marcelle Epley Trust, she had the trust, and the trust said exactly what it's supposed to say: this amount to loved ones, this amount to her donor advised fund, this amount directly to charity. The trust said what it was supposed to say, but the assets were just owned by Marcelle. If that's an unfunded trust, the misconception that a trust avoids probate, you see the problem here. A trust avoids probate for assets that are funded to the trust. So a lot of times what we would see happen with traditional planning is the trust would be created. The attorney would often put the real estate, or at least the primary residence, fund it in the name of the trust. But over a period of a few years plus, people's assets change. They might refinance the house. They might switch jobs and get a new 401k. They might open up a new account. They might switch banks. And what might have at one point been mostly on track, kind of like with my own circumstance, over a period of time, it goes from properly funded to kind of properly funded. And then that's when we run into problems. So here's a poll question. Do you know if your assets are aligned with your estate plan? If what your assets actually say as the owner, as the designated beneficiary, is that in harmony with your estate plan? A few different choices. Yep. My attorney had everything arranged. Yep. I took care of this years ago. I'm not sure, but I assume so. I have no idea. or I don't have an estate plan established yet. We'll give you a few more moments. Okay, great. So it looks like Marcelle, I'm controlling the poll. Is that okay? Okay, perfect. So, okay, somebody else shared the results. So it looks like we've got some people who say a little more than half saying, yeah, that's taken care of, and a little less than half saying, I'm not sure. Our experience is that for people who say, yes, it's all taken care of, that really probably about half of them are really all taken care of. It's one of the things we do is we double check it. But those of you who have everything taken care of, assume that you're mostly right and kind of do a double check on that. It's not what you have in your mind, it's what the institution, the bank, the brokerage account, it's what they have on paper. So if the account, if you thought you submitted something to say that it needs to be owned by Marcelle's trust, but it's still owned by Marcelle, that's what we'll control. Marcelle, let me know how I'm doing on time. How many more minutes do I have left?
It looks like we are, we are just at 12:17, so we do have about 30 minutes left. And I don't see any questions in the chat yet. I just want to remind everybody to go ahead and do that if you're thinking of certain questions. But if not, we'll just keep going.
Okay, perfect. So our focus right now, okay, what is a successful estate plan? We have a pretty straightforward definition that I don't think is too broad or too grandiose, and we'll see if you agree. Our focus for the successful estate plan, 4 kind of components, 4 bullet points. Can the trustee, that's the manager of the trust, and you're typically, for a living trust, you're typically, you, and if you're married, you and your spouse are the managers or trustees of your trust while you're alive and healthy. And you would have a backup trustee if you were incapacitated or passed away. First bullet point, we want the trustee to be able to smoothly and quickly take control of all assets. And the way that that's done is the assets need to be aligned with the trust. I had an appointment this morning with a client who is planning on giving a substantial portion of his net worth to a family member who's not ready to manage the funds. And this client's trust says X% to my family member in trust, managed by a third-party trustee, like a corporate trustee, to hold and protect the money and parcel it out to the family member who's an adult who can't manage his own funds. But this client's retirement account, which is a substantial 7-figure retirement account, is currently set to go directly to this loved one. So without going through the trust, so it would just go directly to the loved one. That's an example of the assets not being aligned with the plan. Another example would be, if going back to Marcelle, if she had a bank account in just Marcelle's name and it had $200,000 in it, and she passed away, her trustee, let's say her backup trustee was her friend Stacy. Stacy would try and go take over that account as the trustee, but the bank would say, that's not in the name of the trust, Stacy. You're going to have to go get a court order. And Stacy's going to say, but there's a trust here. And there's a magic wand provision that says that Marcelle may intended for that to be in the trust, but the bank will say, I'm sorry, go get a court order. So those assets have to be aligned with the trust for that first bullet point. The trustee can quickly and smoothly take control of all assets. Second bullet point, both spouses, if you're married, beneficiaries, if they're adults, and the trustee, the manager, all need to understand the plan at a basic level. When people don't understand the plan at a basic level, that's when conflict arises. And when we want these important people in our life to understand the plan, that doesn't mean we need to share dollar amounts. It means we need them to understand the big picture structure and framework. For example, it would be important in an ideal circumstance for a beneficiary like the one I was mentioning for my client, for this adult beneficiary to understand that he may be the beneficiary of this trust someday, or a beneficiary. It's not certain because these trusts can always be changed. But if he is the beneficiary someday, there is going to be a third party managing the funds for him, and that the creator of the trust wants that third party to not allow the beneficiary to have a free-for-all. So that concept is going to be challenging for people to understand. They need to hear it a few times over the years, because my professional colleagues on this call know that in the midst of grief and confusion, people aren't going to necessarily understand what they are supposed to understand. They're going to be hurt, and they're going to feel like that's not how mom or dad wanted it to be done. So they really need to have a basic, solid understanding of the plan. If they do, that third check mark often takes care of itself, because the conflict would be minimized. I'm not saying it's always easy to have some of these open conversations, but if we can, and the creators of the plan can take an arrow or two rather than leaving it for the backup trustee or other family members to take, we're going to have less conflict. And I'm thinking of a family member that I referred to my colleague John Albin on this call, where there's a significant amount of conflict, and it's caused a lot of heartache for the family, that they weren't able all to get on the same page with an understanding ahead of time, and memories conveniently get cut short in the middle of grief. And of course, what we want to do is minimize taxes and fees along the way. One of the ways we can minimize fees is by avoiding conflict. Another way we can minimize taxes is by ensuring that the plan adapts as the laws change and as the family's assets change. So kind of a little more back to basics on the next slide. What is a living trust? A living trust is established during a person or a couple's lifetime. And as we talked about, we want the assets to be put in the name of the trust, or at least the beneficiaries aligned with the overall plan. Once the assets are in the trust, they're managed by the trustee for the benefit of the beneficiaries. So during most people's lives, they are the creators of the trust, the managers or trustees of the trust, and the beneficiaries of the trust. That's why during your life, you can change your trust whenever you want. Okay, and then
Now, Curtis, this might be a good time to interject a question. We do have one when you were talking kind of about the basics of what goes into trust and who's responsible. One of the questions is, should motor vehicles be included as an asset in a trust? So should we put our cars in the trust?
Generally, what we recommend for clients is if it's a regular car, like my family's 2017 Honda Odyssey minivan, that does not need to be retitled into the trust. Passing it to the appropriate beneficiaries through the DMV forms is plenty simple. It would just be, we would perhaps retitle the asset if it was a valuable collectible car, or we might indicate on what we call a personal property memorandum that we would like our 2017 Honda Odyssey minivan to go to our cousin Joe. So for generally 95% of the time for motor vehicles, we do not need to retitle them into the trust. But Marcelle, can you tell your computer to stop switching the slides? Okay, perfect.
I'm trying, and for the audience, we're trying to be fancy with sharing remotes, and every time I click on my screen, it changes your slide. So I apologize, but you go ahead, and hopefully there won't be any more disruptions.
Okay. There we go. So the way to think of it right here is, if it's not that a trust avoids probate, it's that assets properly titled inside a trust avoid a probate for those assets. So it's really an asset by asset circumstance. If Marcelle's trust has her house in the trust, great, no probate. Her brokerage account in the trust, great, no probate. A $200,000 bank account in her own name, that's going to probate, or at the very least, we're going to court to ask the judge, to beg the judge not to have it go probate. So it's asset by asset to avoid the probate. The trust is changeable during your life, and once the creators pass away, it's irrevocable. And none of you are going to be subject to this. With no estate plan, you go to court and the judge decides just based on California law who's going to get your assets. So none of you are going to go through that. One of the components that we really believe in with our way of doing estate planning, we call it our legacy program. I'll tell you more about it in a moment, but one of the components that we have is a family meeting. And so the idea of just creating these documents and telling our loved ones, hey, just so you know, we created the documents. The business card of the attorney is in the binder. The binder is under the bed or it's in the bookshelf. And if anything happens to us, take the binder to the attorney and you'll go in there and push the easy button. That doesn't work. That does not work. That's our perspective. That does not work. So one of the components to make it work is we need to have family meetings. And who do I envision in these family meetings? Who is there when we have them? The creators of the plan, me, other trusted advisors, successor trustee, adult beneficiaries. Sometimes we can have them all in one meeting. Sometimes there's a little bit of conflict already and we have to have certain kids in one meeting and certain kids in another, just as we're warming things up. But to avoid that war scene I showed earlier and to have it, it's never going to be an easy button, but to have it go as a smooth project, we need everyone to have the basic understanding of what we're doing. The backup trustee has to understand what their job is. Don't make it like when you asked your friend if they would be the godparent or guardian of your kids and they said, sure, I'll do that. Thinking like, okay, we're never going to have to do that. Everyone's going to make it to 18, but they have to know more about what's going on with the plan. So next poll. Those of you who have a plan, have you ever had a meaningful conversation with your successor trustee about how your plan is supposed to work? The meaningful conversation is not, will you please be the backup trustee for my family? It's, have you had a meaningful conversation about it? Yeah, we talk regularly and openly about it. Yes, we've talked occasionally about it. No, we don't really talk about it, or no, they'll know what to do. They'll read the instructions when the time comes. So don't be shy, jump in there and tell us what's going on. Okay, we'll give you about 30 seconds more. Okay, go ahead and close it up. We've got a couple people who've occasionally touched upon it. Occasionally touched upon it, I think that's reasonably good. But a majority have not really talked about it. And I think it's really important that they do, because unless they're a CPA, attorney, financial advisor that deals with this all the time and they're your cousin, it's really a big deal and you're putting a lot on their plate at a time that they're subject to a lot of second guessing from the beneficiary. So we want them to be right on track. Okay, so as part of what we do for our legacy program, once we get those nuts and bolts in place, the plan is created. We hold the client's hand through retitling their assets, filling out the forms, that sort of thing. We like to go a little deeper, a little higher level. So we have a couple exercises that we do with our clients. One we call a red, yellow, green zone exercise. got your note, Stacy. Thank you very much. And that is where we ask our clients to help give better guidance to the trustee. If the trustee is going to be carrying out the plan for loved ones who are young or who are not ready to manage their own assets, what types of things, clients, would you like the trustee to eventually say yes to say no to, or it depend on what's going on? And the why a trust, why this trust really gets into, once we've created and put aside money for our loved ones and taking care of their basic needs, what is really the purpose? What's the bigger picture purpose of what we're doing here? If we've provided for their basic needs, for a safety net, for education, for health, and there's going to be more money than that, what family values, what family wisdom are we looking to bake into the plan? And the way that we do it in our firm, so however you're working on that on your own or with your estate planning attorney, I'll tell you how we do it, and just you could incorporate whatever you like from your philosophy into how you think of it. The three cornerstones of the program that we run for our clients who are part of our legacy program is we help with aligning the assets with their plan, really hold their hand and take the lead with that, family and team meetings over time, and then making sure that the plan and the assets get updated proactively as life changes. We don't know what the laws are going to be in 5 years. We don't know what they're going to be in 3 weeks because Congress hasn't told us yet. So those are our central components. And here's how we do it through our legacy program. We kind of have initial conversations, build the strategy for the plan, design out the plan, review the plan, formalize the plan. Then we go through creating the assets, then the family meeting. The assets is a real big component of what we're doing. And then we keep the plan updated so that checking in every 7 years, that's not going to cut it. Checking in every 7 years with your estate planning attorney, too much changes. And here's kind of the traditional way of doing it. Let's build the plan and then call us if you need us. That does not work because people don't look at their calendars and say, mid-December is looking pretty light. Why don't I call and pay my estate planning attorney to talk about some changes that I probably don't need because I still have the same spouse and the same kids. So really the only way that we've found that works when the chips are down is to have the ongoing relationship, be ready to go deeper, have the conversation with the family, get everybody on the same page. And I see that second question, Marcelle. So you let me hit that when it's time to hit it, and I'll hand it back.
Yeah, we're going to go into a bit of the charitable giving piece. So let's save that one, and I think there's a couple others for after that because it might be just part of our wrap up.
Okay, great. So I'll hand it over to you, Marcelle.
Okay, well, let's see if I can control the slides now when I'm supposed to. There, great. Okay, so here's another a poll question. So how should you and how do you want to include charity in your trust? That's why maybe you're here, but how interested are you? So some people might see it as a necessary part of maybe avoiding taxes. Maybe you're already charitable and this is part of who you are. Maybe you want to get your family involved, but you do have some degree of interest. So it looks like between very interested, somewhat interested, and not sure, can I change my mind later? Everybody is saying that they're somewhat interested, which is wonderful. So with that, I will go ahead and get started. And so here's a few options to include charity in your trust. Typically, we see that it's a percentage of the whole trust of value of the assets, or it's a specific amount or what's left over at the very end. There's a couple of options here that are being talked about more and more by attorneys that we work with and financial advisors, and that's a charitable remainder trust and a charitable gift annuity. Both operate kind of similar. They're set up differently. The charitable remainder trust does require an attorney, and it's a much larger gift typically. But what they both do is they provide income via annuity payments. So it might be on a fixed quarter system or an annual basis, but you as a donor, you're making a charitable contribution and you're receiving annuity payments in return. And then according to what your actuarial date is, your lifespan, when you pass on, whatever's left in that trust or in that gift annuity goes on to the charity. So it's a great way to leave your legacy, but then have a little bit of income as well. We do see this typically with real estate, where individuals have maybe an apartment complex they don't want to manage any longer, and they are charitable and they want to turn that apartment complex into a charitable vehicle while still having a little bit of income. The donor advised fund, it's the fastest growing charitable vehicle that's out there. It's the closest you can get to a charitable checking account, and we administer those. There's a few other options as well that you see listed here. Maybe you know the type of causes that you want to support, but you're not quite sure of the charities. A field of interest fund is perfect for you. Maybe you're giving to charity and you're giving to your church now, but and so you know the charities that you want to leave in your trust. You can itemize those, list them, and include them. Or maybe you want to support students that are furthering their education, and that would be a wonderful way a scholarship fund could do that. So the accounts are open now. A little bit of how it's done. They're open now, and then they're activated upon death. So and then they're directed according to your wishes. And one of the questions we get a lot is, can I change my mind later? And the answer is absolutely yes. And the reason why is because you would name one charity in your trust, and that would be the Long Beach Community Foundation. And then on the side, you would have with us on a form I'll show you in a moment, the type of options that you would like us to initiate on your behalf. So here's one fund that we like to talk about, particularly if you have a tie to Long Beach. That's the Community Impact Fund. It supports the most important needs in the community that are happening at that time. So who knows what the issues will be in 10, 20, 30, 40, 50 years, but this fund grows over time. You could name it in your estate plan, and that means that you are leaving your gift to the Community Foundation to support what's happening in our city at that time. And how do you do that? That's a form we call the Memorandum of Philanthropic Intent, or a MOPI for short. And what it does is it gives us information about what your charitable wishes are. And this could be a conversation between, if you're a professional advisor with your client, and then you utilize us on the side for this documentation and eventual initiation. Or this is something that we can sit down with you, or if you're an advisor, your client, and kind of talk about some options. It's a very easy form to use. It's technically an agreement between the client or the donor of the trust, the owner of the trust, and the Long Beach Community Foundation. It could be designated as a charitable beneficiary of your trust. It lives outside your trust, which attorneys like a lot and the clients like a lot, because it can be changed at any time without needing to update your trust. And so, as we know, causes and charities change over time, and maybe you want to change who's on that list as well. And this gives you that real high flexibility to do that. And we act on behalf of your wishes in order to give to the charities that you care about most, or any specifics that you have outlined. You can also have an option to involve your family members. So after you pass on, if you would like your children to work with us, or your grandchildren to work with us to give away money to charity, we have options for that as well. I think the most two comforting things maybe are the last two bullets as well, is that when you're gone, we have that oversight. We will make sure that your wishes are carried out. We have a wonderful board of directors and team, and also a large back office provider in Greater Kansas City that does all of our accounting. Pretty large team with a very local ties that make sure, as fiduciaries, as overseers, as professionals ourselves, that we are binding ourselves to what it is that your wishes are. In addition to that, your money is invested. So you might have a favorite financial advisor, or if you're a financial advisor, you can continue to manage that asset, continue to manage that charitable fund investment portfolio on behalf of your client, which might be passed down to some of the family members, the example I gave earlier. So here's that form. It's on our website. It's very small here, but it's one form. So it's really easy to fill out, and you can list the things that you would like to have included there. So how to talk about charitable planning. And so there's a number of options, whether you're an individual or you're an estate planning attorney, talking to your client. first of all, you may have already identified the charities that you would like to support, and that means you're already ahead of the curve. If not, and you really need to explore that more, talk to us or talk to your client or explore yourself. Think about your current volunteer efforts and what you do in the community that's already part of your interests and your time. And after exploring those interests, invite us to think through your decisions on charitable giving resources, because once we learn what your needs and wants and hopes and dreams are, then we can look in our toolbox and make a few recommendations based off of what's best for you. And here's some guides that we have. They're on our website. We also have printed materials that can take you step by step to explore your options if you need additional support in that way. And why you would choose a community foundation, because you can certainly go direct to a charity and leave them in your estate plan, and that's a more direct way. But you may have other ideas. Maybe you want to list multiple charities. Maybe some of those charities, if they're not in existence when you pass on, you want the community foundation in your corner, because our board has variance power where they can redirect those gifts on your behalf without any interruption of funding. And of course, we have a lot of resources and experience in doing this. And so that especially helps out with funds that don't have specific charities listed, where you need to implore us to look out into the community and fund the causes that you care about most. It's also anonymous, so you can leave that MOPI form we talked about. We keep it private in our locked resources, and that way you know that nobody knows what your plans are. It's just us at the Community Foundation. And I know that we're getting close to the end here, so I want to leave a few minutes for questions. I'm just going to show you our website. I really encourage you to go take a look at longbeachcf.org, because there's a lot of resources here. If you click that Give Later button, you've got calculators for individuals, for professional advisors. You have different tools and resources, laws. You could really explore a lot of this stuff on your own. Here's that donor advised fund. I know there's a question about an IRA rollover that we'll address, charitable lead trust, and a few things that I talked about. Specifically for professional advisors, we do have resources and documents there, a few that I have already talked about, including the Memorandum of Philanthropic Intent. And really what we hope you took away for today in a very brief amount of time is that there's a lot of different ways to explore your clients' legacy wishes. There's a lot of options. So contact us and let's learn and find out together what it is that they would like to have happen. And on the estate planning side with Curtis, if there's a major takeaway, it's really make sure that people are talking, and it's not the most comfortable subject. And a lot of people wait till it's too late, or they wait until there's a major life incident. But have those conversations now. It's so much better to do that up front. And remember, not one size fits all. There's a lot of different options we can explore together to execute what your wishes are. And don't rely on that magic wand. You've got to have ongoing maintenance. So at least making sure you're looking at your trust once or twice a year. We will go into Q&A now. And Curtis, I think that there's some for you. I'm going to go ahead and read them off.
No, I'll go ahead and do it. I think it'll be easier.
Oh, go ahead. You've got access to it. Yeah, go.
Okay, perfect. Right, so David asked, should named beneficiaries of IRAs be the family trust or the spouse of the IRA holder? And David, case by case, but in the person I was talking about earlier, the example, this person was single and was naming a individual beneficiary, but that individual beneficiary wasn't qualified to manage their own money. So in that circumstance, it should have gone to the trust. For most married couples, most of the time, we are going to name the spouse as the primary beneficiary. Where it would be different is if the owner of the account wants to take care of their spouse during their spouse's life, but then wants to control where it goes after that. So the simplest way would be name your spouse, and then it becomes their account, and you have a handshake deal with them that they're going to make the same beneficiaries ultimately that you would have. But if you're not comfortable with the handshake deal, sometimes that's with blended families, then you do have to work with your estate planning attorney on tying in some sort of trust. Cynthia, who's a CPA, she mentioned that for her IRA account, she made the charities as the beneficiaries, which is a win-win. And that's something that I just talked with a client about today. This client was very charitably inclined. And so we were talking about, I said, there's two great choices. I said the number two great choice is name the charities directly as the beneficiaries, but the even slightly better great choice is to have a donor advised fund and to have the charitable beneficiaries be the donor advised fund, because you can have flexibility on how your successor helper on the donor advised fund actually carries that out. And it's a little bit easier for the charities to go get the money from the donor advised fund than it is for them to get it straight from the retirement account. I see Marcelle nodding along with me.
Absolutely. Yeah. And I have the slide up here because we're going to get wrapped up, but please, Curtis, finish your thought.
That's really my thought. So I'm glad that people asked the question, and Cynthia shared her comment about her retirement account. Those accounts do not get owned by the trust from day one. If it's my retirement account, it's owned by Curtis Kaiser. And together with your estate planning attorney, you need to figure out who it should go to after that. If you have a spouse, should it go to the spouse, or should it be locked in to take care of the spouse and then the kids? And the law changed on those retirement accounts very significantly 2 years ago. So if you haven't talked with your estate planning attorney about your retirement accounts in the last 2 years, definitely do so.
Curtis, it was such a pleasure to have you as our guest speaker today. We really appreciate the information that you have provided, so valuable. And we'd like to encourage everybody, just contact Curtis directly. If you're not already working with a estate planning attorney, contact us and let's have those conversations about what would work for you or your client. And we really look forward to hearing from you and seeing you. We'll send a survey. It will take just a moment, but it helps us fine tune these to make sure that they're really valuable for the community. I'm Marcelle Epley. It's been a pleasure to see you all today. Happy holidays, happy new year, and we'll see you soon.
Thanks, everyone. Thanks, Marcelle.